Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's content, we are going to try to cover the entire 2021-2022 Supreme Court decision term, every Mauritz decision they issued. Let's do them all. That sounds like fun. And then that will be like, I don't even know how many stories that is, because I'm not even sure how many Mauritz decisions they had this term. I guess I should have probably looked that up before committing to it. Hold on. Let me see if I can find out real fast. Where would this be? It'd probably be on SCOTUS blog with the numbers. How many decisions were there this term? Let's see. That doesn't help. That doesn't help. There's some number of cases. I think it might be 60. I think it might be 80. It's some number of cases. It doesn't really matter. We're going to do them all. And that's the idea. And we're just going to start at the beginning of the term. Actually, there's a real easy way to determine this because it's just by R number. Why are you making this complicated? Oh, there's 66 cases this term. Excellent. Execute Order 66. I'm not even kidding. There were 66 cases. 66 merit decisions this term. No problem. We're going to do them all. And that on the plus side means that I can edit this, and that makes 66 individual videos. So that's a lot of content. Some of them will be short. Some of them will be long. Some of them will be confusing. But it will all be interesting. And we are going to try to also turn this into a fundraiser because I want to try to give back as well, because you guys have been so generous to me in helping the channel grow. You guys have been wonderful in helping me reach the 100,000 target, something I was really looking forward to doing before I left my job. And I want to, and this isn't the first charity stream, obviously. We're continuing a previous charity stream. We're funding Be the Match, which does... Pardon me. I may choke at some point. That's okay. Literally and figuratively. We're funding Be the Match, which does bone marrow transplant, support, research, awareness, and so forth and so on. So you can donate. You can donate financially, and also you can donate by becoming a bone marrow donor, where 80% of the time, in order to be a bone marrow donor, they just basically draw blood. It's essentially the same as just giving blood. So even under more modern techniques, it's not even as invasive as it once was. So we are funding research, awareness, so forth, towards Be the Match. So every dollar you give for today's stream automatically goes 100% to charity. So, yeah, great. All right, so we're going to do that. All right, so let's go ahead and get started with all that. And then I need the timestamps because I need to change, because I need to add in timestamps as I go. This is going to be interesting trying to do timestamps on top of this. I thought I had my margins all nicely set up, and now it just looks weird. You hate it when things don't go right technically. All right. So do I do the intro like 66 times? I don't know. Probably not. Yeah, I guess I'll do the intro 66 times. It'll just be really, really weird. That's fine. At least 66 times, because obviously you have to redo it for every single one, because you'll have to do it more than one time. This is going to be an interesting stream for sure. It'll be interesting on the video editing as well. Color correction card. All right. I might have to do the intros afterwards because I won't know what the case is going into it. I might have to do this backwards. All right, we'll give this a shot, see how this goes. All right, so for today's case, we'll be discussing the case of Daniel Rivas-Villegas versus Ramon Cortesluna from the United States Supreme Court, and this is a per curiam decision, so that means there is no listed author, and it's issued in the name of the court. Yeah, so let's go ahead and get started. You think the hat is backwards? It's not. It's a fitted hat. It only goes on one way. Petitioner Daniel Rivas-Villegas, I think. Petitioner Daniel Rivas-Villegas. Petitioner Daniel Rivas-Villegas, a police officer in Union City, California, responded to a 911 call reporting that a woman and her 2 children were barricaded in a room for fear that the respondent, Ramon Cortesluna, the woman's boyfriend, was going to hurt them. After confirming the family had no way of escaping the house, Rivas-Villegas and other officer presented command to Cortesluna outside and onto the ground. Officers saw a knife in Cortesluna's left pocket. While Rivas-Villegas and another officer were in the process of removing the knife and handcuffing Cortesluna, Rivas-Villegas briefly placed his knee on the left side of his back, later sued excess force. All right, so we have a basic fact scenario here. We've got a police officer in the state of conducting an arrest. We've got a guy who is threatening some people. He's ordered outside by the police. He has a knife in his pocket. And while in the process of removing the knife from the pocket and handcuffing the suspect, the officer, in the course of this, briefly places his knee onto his back. So we're going to try to sue for excessive force. Okay, so let's see if that makes any sense. Thank you, I, for $20 donation, and thank you, Teens Tennessee, for $20 donation to be the match. We appreciate your financial support. At issue here is whether Rivas-Villegas is entitled to qualified immunity because he did not violate clearly established law. The undisputed facts are as follows. A 911 operator received a call from a crying 12-year-old girl reporting that she, her mother, and a 15-year-old sister had shut themselves into a room at their home because of the mother's boyfriend. Cortesluna was trying to hurt them and had a chainsaw. That sounds like a threat to me. The girl told the operator that Cortesluna was always drinking, had anger issues, and was really mad, and was using a chainsaw to break something in the house. As we're trying to determine what is and is not excess force, of course, what matters quite a lot is what's in the mind of the officer. What does the officer know and what doesn't he know? And what can he rely on and what doesn't he rely on? Before we can even get to questions like qualified immunity, we have to first determine the officer's mindset and what they do know and what they don't know. So it seems like what the officer here knows is that this person has a chainsaw and is behaving in a way that seems very aggressive to other members of the household. So he is a threat, a clear and present danger, one might say. So that's probably going to dictate quite a lot of the actions that are going to incur as a result of this. A police dispatcher will relay this information along with the description of the suspect in the request for the officers to respond. So the officers know all that. Great. Rivas-Villegas heard the broadcast and responded to the scene along with 4 other officers. The officers spent several minutes observing the home and reported seeing through the window a man matching Corteluna's description. One officer asked whether the girl and his family could exit the house. Dispatch responded that they were unable to get out and confirmed the 911 operator had heard sawing in the background and thought that Cortesluna might be trying to saw down the door. Again, this is going to go to a lot to the officers' actions and the legitimacy of their too. Thank you, $5 from Anonymous for helping to support bone marrow cause. It is appreciated. After receiving this information, Rivas-Villegas knocked on the door and stated loudly, "Police department, come to the front door. Union City Police, come to the front door." Another officer yelled, "He's coming," and has a weapon. A different officer then stated, "Use less lethal," referring to a beanbag shotgun. When Rivas-Villegas ordered Cortesluna to drop it, Cortesluna dropped the weapon, later identified as a metal tool. Rivas-Villegas then commanded, "Come out, put your hands up, walk towards me." Cortesluna put his hands up, and Rivas-Villegas told him to keep coming. As Cortesluna walked out of the house and towards the officer, Rivas-Villegas said, "Stop, get on your knees." Plaintiff stopped 10 to 11 feet from the officers. Another officer then saw a knife sticking out from a front left porch onto Cortesluna's pants and shouted, "He has a knife in his left pocket, knife in his pocket," and directed Cortesluna, "Don't put your hands down, hands up." Cortesluna turned his head towards the instructing officer, but then lowered his hands in head and hands in contravention of the officer's order. Another officer twice shot Cortesluna with a beanbag round from the shotgun, once in the lower stomach and once in the left hip. After the second shot, Cortesluna raised his hands over his head. The officer shouted for him to get down, which he did. Another officer stated, "Left pocket, he's got a knife." Rivas-Villegas then straddled Cortesluna. He placed his right foot on the ground next to Corteluna's right side with his right leg bent at the knee. He placed his left knee on the left side of Corteluna's back, near where Cortesluna had the knife in his pocket. He raised both of Corteluna's arms behind his back. Rivas-Villegas was in this position for no more than 8 seconds before standing up while continuing to hold his arms. This sounds like reasonable force. Again, reasonable force is determined by the fact-specific scenarios. It depends. What does the officer know? What doesn't he know? What is the situation? How is the situation evolving? How is the situation changing? And what might be reasonable one moment is not necessarily reasonable the next moment, because obviously the facts are changing. But in this particular factual posture, it seems like the officer is acting fairly reasonably. The officer is confronting someone who has a weapon, has so far refused commands, has been shot by less lethal devices, and has now been put down on the ground, and in part of the arresting procedure, puts his knee on his back for 8 seconds in the course of conducting the arrest. This seems very, very reasonable and not to be a problem in terms of a excess of force. Of course, if it had gone on for 80 seconds or 800 seconds, that might be a very different posture, but that's not the posture we're in. What matters are the facts that are relevant to this case. At that point, another officer who just removed the knife from Corteluna's pocket and tossed it away came in handcuffed Corteluna's hands behind his back. Rivas-Villegas lifted Cortesluna up and moved him away from the door. Cortesluna brought suit under 42 U.S.C. 1983, claiming excessive force in violation of the Fourth Amendment. This sounds like proportional force, and even if not, it's not something that's clearly a violation. The district court granted summary judgment to the officer, but the Ninth Circuit over here somehow reversed. So, yeah, that doesn't sound like... Whatever the line for qualified immunity should be, assuming it should exist at all, then this is not it. And even if we abolish qualified immunity and we went back to the old standards, this still wouldn't be a violation. right? If we went back to before the idea of qualified immunity, and we went back just to the pure concept of what would a reasonable officer do in this situation, the reasonable man test is kind of the alternative to qualified immunity. What would a reasonably prudent person do in this situation, right? So even if we abolish qualified immunity, it wouldn't help. So this is definitely not the case to do any of those things. This is what we call in law a bad vehicle to do something. So even if you were inclined to reverse qualified immunity, this is a bad case to do it in. It's a bad vehicle for that because the facts don't really lend themselves to that kind of a conclusion. So it's not particularly a wonder, therefore, it's a per curiam decision, because the Supreme Court's going to just be like, no, what are you talking about? This doesn't make any sense. The Ninth Circuit is off their rocker, which, not for the first time. The Court of Appeals of the Ninth Circuit held that Rivas-Villegas is not entitled to qualified immunity because existing precedent puts him on notice the conduct constituted excessive force. Really? In reaching this conclusion, the Court of Appeals relies solely on Lalonde versus County of Riverside. The court acknowledged the officers here responded to a more volatile situation than in Lalonde. It's going to be fact-specific. Reasonable force is dictated by the situation. Nevertheless, it reasoned, both Lalonde and this case involved suspects who were lying face down on the ground and who were not resisting either physically or verbally, on whose back the defendant officer leaned with a knee, causing alleged significant injury. But it's for 8 seconds, though, right? This is quite a different fact pattern than other ones we've seen. The amount of time, what the officer knows, what they don't know, their ability to perceive, and so forth and so on, is quite different than in other notable cases. Judge Collins dissented. As relevant, he argued the facts of Lalonde are materially distinguishable. I would think so. And therefore insufficient to make clear to every reasonable officer the force used was excessive, which also implies the force was excessive, which also is not clear. So you have a couple different problems. Is the force excessive in some sort of absolute sense is one question. Then if we're on qualified immunity, is it clearly established? And even if we're not doing qualified immunity, if we want to abolish that, what would a reasonable officer perceive in this situation? Going back to the old standard. So it's like no matter how you slice it, it doesn't seem like it gets you to the end of the page. We agree and therefore reverse. Even assuming the controlling circuit precedent clearly establishes law, for the purposes of 1983, Lalonde did not give fair notice. He's therefore entitled to qualified immunity. This is a bad case to try to reverse qualified immunity on. Qualified immunity attaches when an officer Qualified immunity attaches when an official's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. A right is clearly established when it's sufficiently clear that every reasonable official would have understood what he's doing violates that right. Although this court's case law does not require a case to be directly on point for the right to be clearly established, and although it's true it doesn't have to be directly on point, the overall thrust of the case law is it has to be really, really close. Really close. Existing precedent must be placed seeing the question beyond debate. This inquiry must be taken in light of the specific context of the case, not as a broad proposition. Again, when they say not as a broad proposition, they really mean it. You have to find something that is very, very close to overcome qualified immunity, which may be a reason to overturn qualified immunity, but not on the basis of this case. Specificity is especially important in the Fourth Amendment context, where it is sometimes difficult for an officer to determine how relevant legal doctrine, here excessive force, will apply to the factual situation. We're all, of course, assuming this is excessive force, which, again, given the description of the situation, does not at least seem readily apparent. Whether an officer has used excessive force depends on the facts and circumstances of each particular case, including severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officer or others, and whether he's actively resisting or attempting to evade arrest. He had a chainsaw and was trying to chainsaw down the door with people involved. He might be a bit of a danger, even if the chainsaw is no longer in his hands. Seems like he might be a bit of a volatile guy. The Graham and Gardner standards, which are classics in this domain, are cast at high levels of generality. In an obvious case, these standards can be clearly established law, even without a body of relevant case law. Yeah, this is not those cases. But this is not an obvious case. It's not even close. Thus, to show a violation of clearly established law, Cortesluna must identify a case that put Rivas-Villegas on notice his conduct was unlawful. Excuse me. Thank you, Deanna Vassello, for $20 to support charity. Thank you for helping to bring attention to bone marrow transplants. You are a scholar. You're hearing a background echo, are you? Testing 1 2 1 2. Is there? I mean, there's going to be a little bit of echo because the room isn't sound treated, but it should be fairly minimal because I have some sound processing on to help reduce it. Let me just check the filters real fast and see if they're kicking on. Let's see. Yeah, de-echo, hum removal, remove room noise. All right, let's check this plugin. A bit of reverb, but not bad. Yeah, okay. Testing 1 2 3. No, that's not what I wanted to do at all. Excuse me. All right, de-echo. Yeah, so the echo is done first as the first processing tool. Let me double check this. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today is the day in which I earn that subscription. For today's story, I am just doing some filler words for the purpose of helping my bot to learn where my voice is and the echo is, in the hope that it will be able to deal with echo reduction. So let's get started with this. Check 1 2 1 2. Check 1 2. All right. Is that any better? It's already at 9. I could reduce it to 10. I don't want to be overly processed. So there is going to be a little bit of reverb. I could turn down the gain, I suppose, but yeah. Am I too funny? Well, I'm glad you like the humor. All right, carrying on. Yeah. So I use RX Audio Tools, by the way, for those of you who are curious. RX Audio Tools suites, they have some sound processing tools, one of which is to remove room echo. And I can show you by turning it on and turning it off, for example, how it works. So I'll show you by turning off the filter, what happens when you turn off the filter and what the room sounds like. Okay, so this is what the room sounds like naturally without any filtering. This is what the room sounds like naturally without any sort of processing to reduce echo. There's obviously some echo in the room. So yes, so it's like, how do you deal with that problem? Well, one way is to treat the room, obviously, and that's a superior way, would be to treat the room by reducing, by doing things to reduce the echo in the room. That's an option. For a bunch of practical reasons, I don't want to do that option. So we go with option number 2, which is where I click this button. And when I click the button, the room echo disappears, or at least is a lot better. So yeah, that's the difference between the two things. It's one of the reasons that OBS kicks ass over StreamYard. But in your kitchen, it's all I have. It's all I have. It's a 1-bedroom apartment. I don't really have anywhere else to set it up. I suppose in the future, maybe I could do a 2-bedroom apartment, and then I could treat a room that would be for the recording purposes, and maybe I'll do that in the future. But this is all I have for the moment. So yeah. Yeah, so. Yeah, it'd be a bad place to treat, yeah. Cortesluna has not done so. Neither Cortesluna nor the Court of Appeals identified any Supreme Court case that addressed facts like the one at issue here. Instead, the Court of Appeals relied solely on its precedent in Lalonde. Even assuming the circuit precedent can clearly be established law for the purposes of 1983, Lalonde is materially distinguishable and does not govern the facts of this case. In Lalonde, the officers were responding to a neighborhood complaint that Lalonde had been making too much noise in his apartment. When they knocked on Lalonde's door, he appeared in his underwear and t-shirt, holding a sandwich in hand. Awesome. Lalonde testified that after he refused to let the officers enter his home, they did so anyway and informed him he would be arrested for obstruction of justice. That is not obstruction of justice, by the way, although a lot of officers seem to think it is. One of the officers then knocked the sandwich from Lalonde's hand and grabbed Lalonde by his ponytail and knocked him backwards to the ground. This sounds very like excessive force. Them refusing the police to come into your home is not obstruction. You have a Fourth Amendment right. After a short scuffle, the officer sprayed Lalonde in the face with pepper spray. At that point, Lalonde ceased resisting. Another officer, while handcuffing Lalonde, deliberately dug his knee into Lalonde's back with force that caused him long-term, if not permanent, injury. That sounds a lot different from this current fact pattern. So even if you think Lalonde is excessive force, which it sounds a lot like it is, not for at least the reasons that Lalonde wasn't doing anything illegal by refusing the police's entry. So their behavior was completely disproportionate. So even if you think that was, this is not. These are two very different cases. We can hear your knuckles banging against the underside of your desk. No, you probably can't because my knuckles are nowhere near my desk. So, yeah. Yeah. The situation in Lalonde and the situation at issue here diverge in several respects. In Lalonde, officers were responding to a mere noise complaint, whereas here they're responding to a serious alleged incident of domestic violence, possibly involving a chainsaw. In addition, Lalonde was armed. In addition, Lalonde was unarmed. Cortesluna, in contrast, had a knife protruding from his left pocket for which he had just appeared to reach. Further, in this case, video evidence shows, and Cortesluna does not dispute, that Rivas-Villegas placed his knee on Cortesluna for no more than 8 seconds and only on the side of his back near a knife that officers were in the process of retrieving. Lalonde, in contrast, testified the officer deliberately dug his knee into his back where he had no weapon and made no threat when approached by police. These facts, considered together in context of the particular arrest, materially distinguish the facts from Lalonde. Also, by the way, for what it's worth, although for edited videos, which this will eventually be, so this entire live stream I think will probably remain up no matter what I do. Maybe it will become unlisted, but I don't know. I mean, technically this is a batch record, but it's a different batch record. It's also for charity. So anyways, but it doesn't matter. My point was, when I do edited videos, I run all the audio again through another piece of audio processing to even make the sound even better. So whatever audio, so there's like there's like basically a couple levels of audio processing. There's StreamYards, which has no audio processing whatsoever, and so it's total garbage, and I hate it. Then there's OBS, which you're listening to right now, which has quite a bit of audio processing. It removes the room hum noise. It removes, so that you can't even hear incidentally, but that's like the electrical noise, like the 60 hertz noise. It removes that. It removes any sort of background noise that's there. So you can, that's why I was silent for a while I was letting the audio readjust, because it takes a capture of the room noise, right? And then it sets all the thresholds to the room noise level. So that's pretty cool, right? So it's only when you capture audio above the room noise level, the mic actually, well, for your purposes, picks up. So it basically gets rid of all background room noise. Then there's a piece of audio software that does the de-echoing thing, which you heard. And then there's compression to help get the audio within certain ranges and stuff. So there's quite a lot of audio processing tools I have to try to make the audio better when I'm doing live streaming through OBS. One of the reasons I like OBS. But even that's not enough, because I want a good quality product. So when I release edited videos, I run them through Audiophonic, which is a website. You can go get an account yourself, Audiophonic, and it does basically automated audio massaging, and it's very good at it. So I run it through all that so the audio will be as good as possible given the underlying limitations of what we're working with. It's like, so I can't really change the room. So since I can't really change the room, then, we do that and it works out great. So all that stuff. Okay. Cortesluna, in contrast, had a knife protruding from his left pocket, for which he had just previously appeared to reach. Further in this case, video evidence shows, and Cortesluna does not dispute, that Rivas-Villegas placed his knee on Cortesluna for no more than 8 seconds, and only on the side of his back, near the knife the officers were in the process of retrieving. Lalonde, in contrast, testified that an officer deliberately dug his knee into his back when he had no weapon and made no threat when approached by the police. These facts, considered together in the context of the particular arrest, materially distinguish the case from Lalonde. Precedent involving similar facts can help move a case beyond otherwise hazy borders between excessive and acceptable force, and thereby provide an officer notice that a specific use of force is unlawful. On the facts of this case, neither Lalonde nor any decision of this court is sufficiently similar. For that reason, we grant Rivas-Villegas petition for certiorari and reverse the Ninth Circuit determination that Rivas-Villegas is not entitled to qualified immunity. So, my friends, that brings us to let me bring it back to the top, which is what I normally do when I'm doing the outro. I normally like to put the title of the thing on screen when I'm doing the outro, in case people want to Google it. I like to put the title on the court. So it's like, what case is this? Well, I put the title on screen so people can find it. Thus, that brings us to the end of the case of Daniel Rivas-Villegas versus Ramon Cortesluna. In this case, we learned an officer responding to a threat of a person who had tried to hack up people with a chainsaw, put a knee on someone's back for 8 seconds while trying to remove a knife from the guy's pocket. The Ninth Circuit apparently found this to be excessive force and also clearly established by the case law. Now, I dispute all those things. I'm not a big fan of qualified immunity, as anyone on this channel knows. I think it's a problematic doctrine, not for the least of reasons that the circuit courts never clearly established the law. If they clearly established the law, it wouldn't be so bad, but most of the time they avoid it. So it winds up being basically something that's very, very difficult. But for whatever criticisms I have of qualified immunity, this is a bad case to try to reverse it on. Because it's not even clear that even without qualified immunity, he'd be liable. Because then we're just back to the reasonable officer test, which is just the reasonable man test. What would a reasonable person do given what they know? And here this seems very reasonable and proportionate to the force. So it's not a big surprise that they lost the case, and that brings us to the end of the consideration of this case. And now I'm going to do the intro for the video I just did. For today's case, we discuss a situation where an officer put a knee on someone's back, but under circumstances that made it clear that he was justified. All right, and thus ends that video. Great. That was fun. Let's do another one. All right. City of Tahlequah. City of Tahlequah versus Bond. Great. Let me go ahead and put in something in the description to put a thumb stamp on. We are 34 minutes and 45 seconds into this. So 34:45. Put a timestamp in. Great. Great. Fantastic. Let's do this. For today's story, we are discussing the case of... Okay, let me try this again. How do I want to do this? I don't know. All right, I'll just do it this way. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's case, we're discussing the Supreme Court's decision in the city of Tahlequah, Oklahoma versus Austin Bond. So we're going to discuss this recent decision from the U.S. Supreme Court, so let's go ahead and get started with this. This is a per curiam decision, which means no listed author, which means the court is speaking as a combined whole. Thank you very much, Courtney, for your $20 donation to help bring attention, awareness, and support to bone marrow transplants. Your donation is extremely appreciated. On August the 12th of 2016, Dominique Rollis' ex-wife Joy called 911. Rollis was in her garage, she explained, and he was intoxicated and would not leave. Joy requested police assistance, otherwise it's going to get ugly real quick. The dispatcher asked whether Rollis lived in the residence. Joy said he did not, but explained that he kept the tools in her garage. Officer... Who gets the money is real? The money is very real. It's going to charity. It's direct support through it. Doesn't pass through my hands. It's direct support. It's, yeah. Officer Josh Gurner, Chase Reed, and Brandon Vick responded to the call. All three knew that Rollis was Joy's ex-husband, was intoxicated, and wouldn't leave the home. Joy met the officers out in front and led them to the side entrance of the garage. There, the officers encountered Rollis and began speaking with him in the doorway. Rollis expressed concern the officers intended to take him to jail. Officer Gurner told him that they were simply trying to give him a ride. I bet they were. To where is the real question. Rollis began fidgeting with something in his hands, and the officers noticed he appeared nervous. Officer Gurner asked if he could pat Rollis down for weapons. Rollis refused. Police body camera video captured what happened next. As the conversation continued, Officer Gurner gestured with his hands and took one step towards the driveway, causing Rollis to take one step back. Thank you very much, Sherry Nordmeyer, for your $100 donation to Be the Match. You are helping to fund awareness, support for bone marrow transplants. It is extremely supported, appreciated. And thank you, Alan Parker, for your 50 pounds of it. Does per curiam always mean 9-0? No, it does not. No, it does not. It just means that the court is speaking as a whole, whatever that means. Bush versus Gore was a per curiam decision. It was decidedly not 9-0. So what exactly it means as a matter of practicality, I don't know. But it's a thing. And not every unanimous decision is per curiam either. You have lots of unanimous decisions with listed authors. So exactly what it means is a little bit, Police body camera video captured what happened next. As the conversation continued, Officer Gurner gestured with his hands and took one step towards the doorway, causing Rollis to take one step back. Rollis, still conversing with the officers, turned around and walked towards the back of the garage where the tools were hanging over a workbench. Officer Gurner followed, the others closely behind. No officer was within 6 feet of Rollis. The video is silent, but the officers stated that they ordered Rollis to stop. Rollis kept walking. He then grabbed a hammer from back wall over a workbench and turned around to face the officers. Rollis grasped the handle of the hammer with both hands, as if preparing to swing a baseball bat, and pulled it up to shoulder level. The officers backed up, drawing their guns. At this point, the video is no longer silent, and the officers can be heard yelling at Rollis to drop the hammer. He did not. Instead, Rollis took a few steps to the right, coming out from behind a piece of furniture so that he had an unobstructed path to Officer Gurner. He then raised the hammer higher back on his head and took a stance as if he was about to throw the hammer or charge the officers. In response, Officer Gurner and Vick fired their weapons, killing Rollis. The estate filed suit against the officers, claiming they were liable under 1983 for excessive force. Yeah, I'm not really seeing the excessive force particularly on this one, right? The guy is resistant, and more to the point, he has a hammer in his hand, and he's raising it up to try to like act like he's going to strike. This seems like a lethal threat, right? It seems like an imminent threat. I mean, if just a guy is, confronting me and has a hammer, and he's bringing it up to strike me, this seems like a deadly threat. So this seems particularly suitable for a self-defense claim, but let's read some more. The officers moved for summary judgment, both on merits and qualified immunity. Yeah. The officer's use of force was reasonable, it concluded, and even if not, qualified immunity prevented the case from going further. Right. A panel of the Court of Appeals for 10th Circuit reversed. Really? The court began by explaining the 10th Circuit precedent allows an officer to be held liable for shooting that itself is objectively reasonable. Really? Okay. If the officer's reckless or deliberate conduct created the situation requiring deadly force. I guess, yes, possible, but what exactly is that in this scenario? Applying the rule, the court concluded a jury could find the officer Gardner's initial step towards Wallace and the officer's subsequent cornering of him in the back of the garage recklessly created the situation that led to the fatal shooting, such that their ultimate act was unconstitutional. No, I'm not quite sure how that works. For a civilian, maybe. When you're trying to take steps towards someone and trying to force them into a corner, yeah, that could do it for a civilian. But when you're the police trying to deal with a suspect, that's kind of a different scenario. The use of reasonable force must be judged based on the particulars of the scenario. And here the particulars of the scenario are such that this seems quite proper, but the 10th Circuit apparently had questions. As to qualified immunity, the court concluded that several cases, most notably Allen versus Muskogee, clearly established the officer's conduct was unlawful. This petition followed. Thank you, Alan Parker, for the £50 donation, and thank you, OctoPP, for 10 Swiss francs. And thank you, Noah B, for £5 to help support bone marrow transplant awareness, support, and the rest of it. It is appreciated. We need not and do not decide whether the officers violated the Fourth Amendment in the first place, or whether recklessly creating a situation that required deadly force itself can violate the Fourth Amendment. On this record, they plainly did not violate any clearly established law. The doctrine of qualified immunity shields officers from civil liability so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. As we've explained, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. It does take quite a lot to violate qualified immunity, and this definitely is not it. We have repeatedly told courts not to define clearly established law at too high a level of generality. It is not enough a rule be suggested by then current existing precedent. The rule's contours must be so well defined, it would be clear to a reasonable officer that conduct was unlawful in the situation they confronted. Having some itchiness issues. I love it when I have these issues where my eye just starts flaring up. Such specificity is especially important in the Fourth Amendment context, where it is sometimes difficult for an officer to determine how a relevant legal doctrine, here excessive force, will apply to a factual situation the officer confronts. The 10th Circuit contravened those settled principles here. Not one of the decisions relied upon by the Court of Appeals comes close to establishing an officer's conduct was unlawful. The court heavily relied on a case called Allen, but the facts of Allen are dramatically different from the facts here. The officers in Allen responded to a potential self-harm call by sprinting towards a parked car, screaming at the suspect, and attempting to physically wrest a gun from his hands. The officers, by contrast, engaged in conversation with Rolls, followed him into a garage at a distance of 6 to 10 feet, and did not yell until after he picked up the hammer. We cannot conclude that Allen clearly established their conduct was reckless or the use of force was unlawful. Excuse me. The other decisions relied upon by the Court of Appeals are even less relevant. As for Seaver, that decision merely noted in dicta that deliberate or reckless pre-seizure conduct can render a later use of force excessive before dismissing the appeal for lack of jurisdiction. To state the obvious, a decision where the court did not even have jurisdiction cannot clearly establish substantive constitutional law. Regardless, that formulation is a rule much too general to bear on whether the officer's particular conduct here violated the Fourth Amendment. In a state of Sibelius, decided after the shooting at issue, it's of no use to the clearly established inquiry. And Hastings, an unpublished decision, involved officers initiating an encounter with a potentially self-harming individual by chasing him into a bedroom, screaming at him, and pepper spraying him. Thank you, Anonymous, for your $20 donation to help support bone marrow transplants. It is much appreciated. Suffice to say, a reasonable officer could miss the connection between that case and this one. Neither the panel majority nor respondent has identified a single precedent finding a Fourth Amendment violation under similar circumstances. That would be hard. This sounds pretty justified. Those officers were thus entitled to qualified immunity. The petition for certiorari and motions to leave to file briefs are granted and the judgment is reversed. Thus, that brings us to the end of the case of the city of Tahlequah, Oklahoma versus Austin Bond. In this case, we learned that officers were approaching a man who was in a garage and behaving strangely and had things in his hand. As the officers were approaching him and trying to talk to him, he decided to back up and the officers tried to get closer. He then decided to have a hammer and start waving it towards the officers. The officers, perceiving this to be a deadly threat, then engaged him and the guy died. And they're trying to say that this is a violation of his substantive due process rights. Again, whatever you might think of qualified immunity, and I have many, many questions about it at best, this is a bad case to review the doctrine. This is a case where the police probably acted properly and acted with due care, in a situation where a normal civilian could use deadly force because of the standards that apply. So, yeah, not surprised about this. Qualified immunity continues to live on, at least for a moment. That brings us to the end of the discussion of this case. For today's story, we discuss a situation coming out of Oklahoma in which officers used deadly force, but against a man who was wielding a hammer, but somehow the court found that it wasn't qualified immunity, and the Supreme Court must review. Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with qualified immunity, a doctrine of which I have been deeply critical on this channel, and a doctrine which should potentially be reviewed. At bare minimum, I think the courts of appeals should do more to clearly establish the law, so we all know what the law is. Unfortunately, right now it's a bit of a catch-22. You can't hold the officers responsible unless it's clearly established, and you can't clearly establish it unless it's clearly established. So it becomes a bit of a problem. But whatever problems it has, this is a bad vehicle for it. In this case, as we're going to review, we have a situation with a man who's wielding a hammer who gets shot by the police. So somehow the 10th Circuit said that this was a problem, but it seems like this is a bad case to review qualified immunity, so let's go ahead and get started with this. Yeah, that's the way I'm going to do it. I'm just going to do the intros at the end, because that's the only way for this to make sense. So it'll be a little bit weird in terms of the video, but that's okay. Kurt's news voice is glorious on point. Excellent. All right, let's do another case. So those are all the cases from the October term. Now we're going to do all the cases from the November term. Fortunately, it's one case. Ooh, original jurisdiction too. Fun. You don't see those very often. Well, fun. Fun is a very loose definition of fun here. Okay, so let's try this again. Okay, so what we've got so far is let's try that one more time. So for today's case, we've got Mississippi versus Tennessee. And as you can see here in the header, this is number 143 original, because this is a case between two states, which means that pursuant to the Constitution, the Supreme Court is the trial court. So this case starts and ends in the U.S. Supreme Court. So this is a case of original jurisdiction versus appellate jurisdiction. The Supreme Court is the trial court. Fun. All right, so let's read this case and see what Mississippi and Tennessee are fighting over. Mississippi brings this original action in which the Supreme Court is the trial court against Tennessee for damages and other relief relating to pumping of groundwater by the city of Memphis for the Middle Claiborne Aquifer, a valuable water resource that lies beneath 8 states. Yeah, unsurprisingly, this deals with water rights. That is very often what the disputes between the states wind up to be. It winds up to be a water rights thing. Mississippi argues that Tennessee's pumping, using wells Mississippi concedes are located entirely inside of Tennessee, siphons waters away from Mississippi and amounts to a tortious taking of groundwater that's owned by Mississippi. Hey, we own that aquifer too. Mississippi expressly disclaims any equitable apportionment remedy, arguing that the fundamental premise of this court's equitable apportionment jurisprudence, that each opposing state has equal right of use of water at this issue, does not apply to the dispute. So one of the things might be, okay, it's an equity issue, because they all own the same water, but they all own the same water. So one of the ways you can deal with this is you deal with this in property law a couple different ways. Right, so you can deal with this as basically tenants in common would be one way, and they basically owe duties to each other, and so they might be responsible for apportioning out the gains that occur from the property to each other. They all have an equal and undivided right to the property. This is called a tenant in common. And then if you have a right of survivorship, it's called a joint tenancy. This is going too much into property law, but these are concepts known to property law, right? Everyone owns the property together, either with right of survivorship or not. And everyone might owe a duty to everyone else in terms of their account of the use of the property. So this is one of the ideas. Maybe that's the issue. But Mississippi is saying this is not the issue. Okay. The special master appointed by the court to assess Mississippi's claim, determined an aquifer is an interstate water resource and that equitable apportionment is an exclusive judicial remedy. All right, so we have this term special master. Ooh, very fancy term, right? And it actually falls into the category of being a big deal. The Supreme Court uses them pretty much every time in original jurisdiction cases because they are the trial court, so technically they could just have the trial themselves, but they're not going to. So they're going to appoint a special master basically to do it for them. But then they get the chance to review everything for the first time. So it's all de novo, no matter what it is, because they are the trial court. So they get to review the special master's review, factual findings or otherwise, all de novo. You sometimes see this, although much more rarely, at courts of appeal and even occasionally at trial courts in particularly complicated factual situations, particularly where they're technically complicated and the court feels like they don't have the right requisite factual background. So you will see sometimes courts appoint a special master. Basically, it becomes a mini judge. And they're the one that basically hears all the case. And the judge sits on top of the whole thing of review and can basically still do whatever they want. So they can ignore the special master, they can do whatever they want. But it's a way to basically appoint a neutral arbiter within the court system. And so you'll sometimes see this. And so being appointed as special master is a big deal. Being appointed as special master at the U.S. Supreme Court is a very big deal, particularly in these water rights cases, because sometimes they go on forever. And sometimes you're a special master for 40 years or something because sometimes these water rights go on forever. So that's basically what happened. The Supreme Court basically appointed sort of a kind of mini judge that the Supreme Court can absolutely do anything with regards to, because they're just assisting, but it's a big deal. And the Supreme Court usually listens because that's the point. Because Mississippi's complaint did not seek equitable apportionment, the special master recommended the court dismiss the complaint but grant leave to amend. Mississippi challenges the recommendation to dismiss. Tennessee objects to the recommendation to grant leave to amend. So they are not, both of them are unhappy. Tennessee wants this to be dismissed without any redress, and Mississippi wants to not have the equitable remedy. The court's going to split the baby. Here, the waters of the Middle Claiborne Aquifer are subject to judicial remedy of equitable apportionment. Mississippi's complaint is dismissed without leave to amend. Ooh, that's a harsh remedy. That's a harsh remedy. Okay, let's read some more. The doctrine of equitable apportionment aims to produce a fair allocation of shared water resources between two or more states, based on the principle that states have equal right to reasonable use of shared water. This court has applied the doctrine to interstate rivers and streams, to dispute over interstate river basins, and in situations where pumping of groundwater has affected the flow of interstate surface water. The court has also applied the doctrine to fish that migrate between the Pacific Ocean and spawning grounds in the Columbia Snake River system, traveling through several states during their lifetime. Who gets control of the fish? Who gets control of the fish? These are the kind of things that the Supreme Court has to solve. Yeah. The court has not before addressed whether equitable apportionment applies to interstate aquifers. So this isn't a river or a water basin. This is underground. So we've never before decided that issue, which I suppose we could decide differently if we want to. Equitable apportionment of the aquifer is sufficiently similar to past applications of the water for several reasons. I mean, I would think so. How is underwater water different than overland water? How is under the land water different than over the land water? It's not really that different, or at least not different enough. First, the court has applied equitable apportionment when transboundary water resources are at issue. Here, the Middle Claiborne Aquifer's multi-state character seems beyond dispute. Second, the Middle Claiborne Aquifer contains water that flows naturally between the states, and the court's equitable apportionment cases all have concerned this kind of water, or the fish that live in it. We are about controlling the water, and we're about controlling the fish. Fine. While Mississippi contends the natural transboundary flow of the aquifer is slower than some streams and rivers, sure, the court has applied equitable apportionment even to streams that run dry from time to time. So even though that there is no water, we are still going to apportion the non-existent water, because that's the level of petty that we have to deal with at the U.S. Supreme Court level as the states fight each other. The speed of flow does not place the aquifer beyond apportionment. Finally, actions taken in Tennessee to pump water from the aquifer clearly have effects on the portion of the aquifer that underlies Mississippi. Tennessee's pumping has contributed to a cone of depression that extends miles into northern Mississippi, and Mississippi itself contends this cone of depression has reduced groundwater storage and pressure in northern Mississippi. So pumping the water out has caused the land to sink. This is, yeah. Such interstate effects are hallmarks of the court's equitable apportionment cases. For these reasons, the court holds the judicial remedy of equitable apportionment applies to waters. Yeah, basically, if multiple different states control the same water, they all have to play nicely with each other. And you all get it equitably. You all have to play nice. No one gets water superior to anyone else's. So just because you're further up in the river doesn't mean you get to steal all the water and or all the fish. And just because you've drilled a well into the aquifer that is within the boundaries of 8 different states doesn't mean that you get to control all the aquifer water. You have to play nice with the other children. You all get rights to the water collectively, and you have to play nice. And if not, then the Supreme Court has to come in and deal with how we have to deal with the fish. Left unresolved is whether or not those fish are bees, and if so, how that impacts the analysis, but maybe it's a different decision for another time. Thank you for I Bella Vita Loca. Thank you for the $150 to the charity. That is incredibly generous. Thank you for supporting bone marrow donation and awareness and the rest of it. Don't forget that you can sign up as well to be a bone donor. Well, that didn't really work. Let's try this again. Don't forget you can sign up to be a bone marrow donor. And according to the bone marrow people, 80% of the time, this is really not much more complicated than drawing blood. So it can be done very simply. So you could save someone's life potentially through very minimal effort on your own part. So thank you for the donation, and don't forget to sign up for Be the Match and become potentially a person who can save someone else's life, potentially through real no effort of your own. Thank you very, very much for your donation to the charity. I almost said super chat, and if I slip up at some point and call it a super chat, you guys will forgive me. It's not a super chat, because 100% of the revenue goes directly to the charity. I don't see it at all, so it doesn't flow through me. So, yeah. Okay, where was I? Okay. The court rejects Mississippi's contention that it has a sovereign ownership right of all the water beneath its service that precludes application of equitable apportionment. I mean, if that were true, that would apply to every state. And then it's just who can pump the water the fastest, which obviously is a somewhat disfavored outcome. The court has consistently denied proposition that a state may exercise exclusive ownership or control of interstate water flowing within our boundaries. It's interstate, so no. Although the court's past equitable apportionment cases have generally concerned rivers and streams, no basis exists for a different result in the context of the Middle Claiborne Aquifer. To the contrary, Mississippi's ownership approach would allow upstream state to completely cut off flow from a downstream one, a result contrary to the court's equitable apportionment jurisprudence. Yeah, it's not just like whoever the water flows through first. All the states get to have some water. Water, not a drop to drink. Everyone has to play nice. The court's decision in Tarrant Regional Water District does not support Mississippi's position. Tarrant concerned whether one state could cross another's boundaries to access shared water resource under the terms of an interstate compact. An interstate compact would be where there's an agreement, so, okay. The court did not consider equitable apportionment because the affected states had negotiated a compact to their respective rights. So yes, in this particular situation in Tarrant Regional, apparently the states reached an agreement between themselves on the whole thing. So then that became the law. They have an agreement. They have a contract. And so, if they have an agreement, great. That's law. If we don't have an agreement, then we're into equity, which is kind of not law, but sort of is. It's a different theory of things. And yeah, so if there's law because you have contract, then great. And so we didn't have to consider the equity because we had law. Fine. Okay. To the extent that Tarrant stands for a broader proposition that one state may not physically enter another to take water in the absence of an agreement, which, yeah. That principle is not implicated here. Surprising literally no one, one state cannot cross into another state's boundaries to take their stuff. No. That's, when one state crosses another state to take their stuff, wars have been fought over less. So, no. The parties have stipulated that all of Tennessee's wells are drilled straight down and do not cross the border. While the origin of the interstate water resource may be relevant to the terms of the equitable apportionment, that feature alone cannot place the resource outside the doctrine. Because the waters contained in the aquifer are subject to the equitable apportionment, because the aquifer exists cross-border, the court overrules Mississippi exceptions and adopts a special master recommendation to dismiss the bill of complaint. So, no. Mississippi has neither sought leave to amend its complaint nor tendered a proposed complaint seeking the equitable apportionment. The court does not address whether Mississippi should be granted such leave and sustains the recommendation to sustains the objection to the special master's recommendation to grant Mississippi's leave to amend. Wow. So we don't address whether or not you should be granted leave, but we sustain your objection to the special master who said no. So maybe you lose all the things because the special master said no. So maybe you lose your rights because you were a greedy Mississippi, and now you don't get any water. So it sucks to be you. Thus, that brings us to the end of the case of Mississippi versus Tennessee, a case of original jurisdiction in the U.S. Supreme Court. Yes, one state can sue another, and when that happens, the Constitution is absolutely clear. The only court that can decide issues between states is the Supreme Court. The Supreme Court is the trial court, and also the Court of Appeals, and also the Court of Last Review. It's a nice place to be, I guess, if you're the Supreme Court. It's like we start and finish here. So yeah, Mississippi and Tennessee are suing each other over water, which is typically how these things go. And they say, yeah, you have to share the water. And then they say, in a nice little burn to Mississippi, because you didn't want to play nice, we're not going to let you amend your complaint. So Tennessee gets to steal your water, and there's nothing you can do about it. Man, that's a lot of burn. Or at least that's the recommendation from the special master. Maybe if Mississippi goes back with hat in hand and asks really, really nice, the special master will reconsider, which they can, mind you, because the Supreme Court is the trial court, remember? And the trial court can always reverse itself on these issues. And the special master is acting as the trial court. So the special master might be able to change their mind. And that would be fine, because it's just the Supreme Court basically changing their mind. But, they might have to learn to play nice with others. And at least for the moment, that brings us to the end of discussion of this case. For today's case, we discuss Mississippi versus Tennessee and how not sharing nicely when it comes to shared water rights can leave someone high and dry. I'm unduly proud of that joke, by the way. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earned that subscription. For today's story, we're discussing Mississippi versus Tennessee, a case of original jurisdiction, which means the Supreme Court is the trial court, and is also its own court of appeals, and is also its own court of last review, because that's what the Constitution says when one state wants to sue each other. Why is Mississippi suing Tennessee? Well, it's the most classic reason of all. It's over water. Because the states like the water and they like to control the water. Unfortunately, this particular bit of water crosses state lines. In fact, it crosses 8 different state lines. But one state thinks that they're entitled to all the water. So are they right? Let's go ahead and get started with this. This is fun. I'm having fun. I am in a good mood. I just like to say, I am in a good mood. I tell you what, I don't know whether or not this is a trend of broader things or not, and one can hope. But as you guys know, because I've talked about my mental health before, because there is this conceit in the zeitgeist of the culture that we should make mental health easier to talk about. So I'm going to try to be part of that change. That seems like a positive thing. This obviously makes me vulnerable, because it puts me in a position where people could choose to make fun of me or exploit me in some way about that, which kind of makes them horrible people. So I'm not really that worried about it, because if they really want to mock me for depression, then that's more about them than me. But whatever. Either way, I've talked about issues dealing with depression, and many of those issues and many of my problems dealing with my own self in terms of overeating, in terms of alcohol, is to some degree, not completely, but is to some degree self-medication. It's also become a bit of addiction unto itself, more the food than the alcohol, by the way, because I haven't had a drink in quite a few days and I don't really desire one, but I definitely desire to just shove my mouth full of food. So food addiction is a real problem when it comes to these things. But and a lot of that has been driven by my job. I had the job for 15 years, 14 years and 11 months to be precise, or 10 months. Yeah, 14 years and 10 months. And for about the last 5 years of it or so, it's become increasingly hard. And I never loved the job. It afforded me a lot of flexibility and time, and it was well paying, but I never really loved the work. And it became monotonous. It became so predictable. There was nothing left. There was no joy left in it because nothing was new. It became mechanical. And it drove, there was no creativity in it anymore. There was nothing left to do in terms of his creativity. And so the fact that I had no creative outlet was a problem. Because lawyers can be creative. They can be endlessly creative. Because one of the things they have to do is deal with novel situations, and the law is often novel. But my field of practice had become so narrow that it became mechanical. There was nothing left for me to do in terms of exploration. And this was driving me into increasing areas of depression, which led to overeat, which in part, again, it's an in part thing, which in part led to overeating, in part led to overdrinking, which is self-medication, right? And so forth and so on. And my last day was officially July 2nd, and I kind of checked out for 6 months or something. But even it's finally happened. It's finally happened that I've left. And although it's only been 5 days, I've seen my mood improve. And I don't know whether or not this will be a continuing upward trend or not, or whether or not it's a temporary ethereal thing. Who can say, right? Who can say how the future will go on such things? But for whatever the future might be, whether or not there's a relapse, or I wind up in a cratering depression, or whatever the situation is, like whatever the future might hold on such things, for the moment at least, I feel positive. I feel good. I feel like I have a lot of energy. I feel like a very positive place. And I feel like I've made perhaps a calculated risk decision in leaving a secure job, but I did it for what were well thought out and quite possibly essential reasons in the end. And so I don't know whether or not this means going forward, whether or not I'll lose a lot of weight, whether or not it means that, I'll have less food addiction, whether or not it means a lot of things. But I'm in a good mood, and I'm glad you guys are here. So thank you for everyone who's been here. I do have a bit of a persona reputation as being a bit of an Eeyore, which I think is somewhat deserved, and because these issues are real. And yeah. Anyways, that's way too much stuff about me. Anonymous, thank you very much for your $50 donation as well. Yeah. The risk of staying, I think, probably was greater in the end. I think that's probably right. It's a very calculated risk because you're giving up security and a very well-paying job. It was paying very low six figures, but it's a well-paying job. I mean, and it affords me a lot of flexibility on time, and there were a lot of things about it. Whole Women's Health versus Jackson. What is this? Oh, this is Texas Heartbeat Act. We covered this. Do I want to cover it again? No, not right now, at least. United States versus Texas. Well, that's a one-sentence decision, so we'll skip that. All right, so that brings us to the end of the December term. So there's Whole Women's Health, which deals with the Texas law with the fetal heartbeat thing. We've covered it before. I don't know that I want to cover it again. Maybe later. Let's see. Babcock versus Kijakazi. Okay, fine. And I haven't done the color card thing in a while, so color correction card. All right, let's go ahead and get started. Okay. This case concerns retirement benefits due under the Social Security Act for a retired military technician of dual status. Under the law, a civilian position formerly held by David Babcock. Like all dual state technicians, Babcock was required to maintain membership in the National Guard. For his full-time job as a technician, which included work as a test pilot and pilot instructor, Babcock received civil service pay and civil service retirement system pension plan from the Office of Personnel Management. So he is, at least in part, a government employee. Fine. For his separate National Guard service, which included part-time drills, training exercises, and one active duty deployment, Babcock received military pay and military pension from a different arm of the federal government, the Defense Finance and Accounting Service. Okay, fine. So he is multiple different things. Okay, fine. Upon retirement, Babcock applied to the Social Security Administration for benefits. The agency granted benefits, but it applied a statutory windfall elimination provision and reduced the amount of benefits to reflect Babcock's receipt of civil service pension plans for his work as a technician. Babcock sought reconsideration, arguing the reduction should not apply because the pension payments at issue fell within a statutory exception for payments based wholly upon service as a member of the United States Armed Forces. So one of the things the Social Security Administration can do is reduce your benefits, at least in part based on other benefits you achieved elsewhere. The idea being that you can't recover twice, which is a kind of a principle that applies in a lot of law, right? So if you want to sue somebody for somebody, you can only recover for the total amount of damages. And if you sue multiple different people for the same thing, you can still only recover the total amount of damages. So if you sue someone for, say, $1 million, let's say there's $1 million in total damages, right? There's $1 million in total damages. Now, you might be able to sue a lot of different people in a lot of different combinations in a lot of different ways. You might be able to sue somebody and get it all from them. You might be able to sue a bunch of people, but what you can't do is get more than $1 million total. If $1 million is your total loss premise, if $1 million is your total loss, what you can't do is get more than $1 million in recovery. In compensation damages, one might note, by the way, in compensation damages. If they're punitives, maybe you can get punitives more than that because there are multiple different people who are responsible. So maybe multiple different people have to pay punitives, but you can't be compensated more than once. So this is a general principle. So this principle in law that you can't have more than one recovery is being applied here as well. Social Security Administration says, okay, you have benefits, but we're going to give you less benefits because you already got your benefits somewhere and you're only entitled to one set of benefits. Okay, that's the idea the Social Security Administration is playing with. He says that general principle, you can't recover more than once, as it were, doesn't apply here because there's a statute that specifically says it doesn't apply here. Okay, let's give that a shot. The agency denied reconsideration, and Babcock exhausted all available agency review, which is something you have to do in the federal system. You have to exhaust all your administrative remedies before you can sue. The district court upheld the decision, and the Sixth Circuit also affirmed. So the agency said no, the district court said no, the Sixth Circuit said no. Okay, what does the Supreme Court want to say? Civil service payments based on employment as a dual status military technician are not payments based on service as a member of a uniformed service. Okay, so this service that he did as a civil service is not based on his military service. It's a different thing. Fine. It might, in some sense, have military aspects to it, but it's not exactly unheard of for civilians to do things related to the military. There are civilians doing military jobs in multiple different senses. And so it's a civil job, not a military job, even though he's also a member of the National Guard. Those are military jobs, but this is not a military job. Fine. Retirees receive Social Security benefits based on progressive formula that awards a percentage of average past earnings. The formula originally did not account for earnings from jobs exempt from Social Security taxes, many of which provide for separate pensions. So not all jobs have Social Security taxes. Fine. In response to this windfall, or potential windfall, Congress modified the formula to reduce benefits when a retiree receives a separate pension. But Congress left benefits unchanged if the pension was based wholly on service as a member of the uniformed military service. So the military is special in this domain. Their benefits are on top of any other benefits. There's not a dual accounting thing for the military. It's one of your benefits by being a member of the military, I guess. The National Guard is defined as part of being the uniformed service. So whether the uniform exception depends on whether his employment as a technician was as a member of the National Guard. So was he doing the work as a technician as part of his work for the National Guard? Were they the ones employing him? It was not. In context, as is read most naturally to mean in the role, capacity, or function of. And the status defines the role, capacity, or function. For purposes of this section and any other provision of law, a technician is a civilian employee assigned to a civilian position and authorized and accounted for as a civilian. He's a civilian in that role, which among other things means he can quit at any time because he's not a member of the military. Technicians hired before 1984, like Babcock, are members of the civil service entitled to pay under Title V of the Code, which governs pay and benefits of civil servants. So the federal government changed its retirement and pension plans system for federal employees in 1984. So there was one system before the civil service plan, and afterwards it's called FERS. So yeah, they're employees who have both, because obviously they're employees who worked before 1984 and after 1984. So yeah, he's in this old school retirement plan, the old school pension plan, which we call the civil service plan instead of FERS. Fine, but he's not a military service. Makes logical sense. Looking to broader statutory context, technicians possess characteristics of civilian rights to seek redress for employment discrimination and to receive workers' compensation, disability benefits, and compensatory time off for overtime. These provisions demonstrate that this is not the military. Yeah. That distinction holds true even though Babcock also served at other times in a different capacity as a member of the National Guard. He had double jobs. His civil service pension payments are not part of that service, for which he received a separate military pension, and that pension does not trigger that windfall provision. He's entitled to whatever additional benefits that pension gives him. That's fine. As a condition of employment, such as requirement that a technician maintain Guard membership is not the same as the capacity in which he serves. So in order to be a technician, he has to maintain Guard membership, but they're still different roles because he could quit the civilian role, right? He may not necessarily be able to quit the National Guard role. So to be a technician, you must also be a member of the National Guard. So he wants to be a technician. So he becomes a member of the National Guard. If for some reason he decides he doesn't want to be a technician anymore, he can just quit. That doesn't, of course, necessarily mean he can just quit being a member of the National Guard, but he can quit because they're separate roles. Great. Babcock contends that technicians' full-time job qualifications, duties, and dress code render it functionally indistinguishable from the Guard service, and the court should interpret as more loosely to capture payments for service in likeness as a member of the uniformed service. That's not the language Congress chose. But the court finds no reason to adopt this meaning of as other than the most natural meaning of as, particularly where Babcock's functional test is inconsistent with the statutory scheme. Yeah, Congress made choices, and those are the choices Congress made. Determining whether Babcock's employment was service as a member of the National Guard does not turn on factors like whether he wore his uniform to work, but rather on how Congress classified the position. Congress, civilian classification of dual status technicians for bookkeeping purposes controls when it comes to pay and benefits. Barrett delivers the opinion of the court in which Gorsuch delivers a dissent. So this is an 8-1 decision. Thus, that brings us to the end of the decision of the Babcock versus the acting commissioner of Social Security. In this case, Babcock wanted to be a technician. A worthwhile goal. But to be the kind of technician he wanted to be, he had to also be a member of the National Guard. So now he's both. Now he's a technician and a member of the National Guard. And he's getting paid by both. And getting benefits of both. And pension benefits and so forth and so on. This is fine. And Babcock enjoyed a long and illustrious career. Seemed to be happy doing it. Eventually, he came to retire from both of these positions, and he wants benefits from Social Security. Social Security looks at the law and says, the law says, among other things, we can deduct benefits you got somewhere else because you've already been compensated once. And Congress passed a law basically said no double compensation. He says, well, there's an exception to that for military service. I can get double compensation if it's military service. Congress said the military is special. And they said, yeah, it is, but this is a military service. So the question is it or not? And the Supreme Court says, no, it's not. Although you are required, apparently, to be a member of the National Guard, that is the military, to be this kind of technician, they are separate positions because he could have quit his position as a technician anytime because it was a civilian role. So he could have just quit. This, of course, does not necessarily impact what he does or does not do for the National Guard. That's an entirely separate matter because now you're a member of the military, son. So yeah, the Supreme Court rules, perhaps unsurprisingly, that he can't collect twice because of the choices Congress made in the statute, and that at least brings us to the end of discussion of this case. For today's story, we discuss someone who worked for both the military and in a civilian capacity, and the question is, can he get all the benefits from both? Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with the case of Babcock versus the Acting Commissioner of Social Security. In this case, Babcock works as a technician. The role of technician in this context requires him to also be a member of the National Guard, which he was, and he did, for many, many years until his retirement. Upon his retirement, he wants Social Security benefits, but the Social Security Administration says that some of those benefits he is not entitled to because it would be a windfall, and Congress doesn't allow for that. So, is Congress right, or is he right? Let's get started with this. Excellent. Good news had by all. All right, great. What's next? Biden versus Missouri. How many of these cases will I get before my voice gives out is now the question. We should take bets. Is this live or just a super edit of prior videos? Well, it's live and will eventually be subsequent videos, right? So this is the biggest batch record of them all. Super batch record. Super batch record. Yeah, CSRS versus FERS. Yeah, exactly. All right. Yeah, we're not going to allow bots in the channel. So my mods are instructed to insta ban the bots. This is a color correction card for those of you who are not familiar with such things, to correct the color in the video later, or at least give me the option to correct the color in the video later, because I'm still working on actually being able how to do that. All right, so let's see. Biden versus Missouri. All right, this looks fine. We'll cover this one. Let's add a timestamp. This is at 1:27. Okay, 1:27 or 1:28, more like it. 1:28, I guess about 15 will be when that case kicks in. And I need this case for the other one for that timestamp. Great. Fine, fantastic. Yeah. This is not a drama channel. So we're not going to discuss drama here. That's all I'm going to really say about that. White balance is typically the standard color corrector. Well, I've got one of those too, but this is there's a white piece in there, but it comes with a gray side if you want that color correction. So what degree do you need to practice in the U.S. as an attorney? You need some sort of, you need some sort of undergrad. Anything will be fine, and then you need a law degree. And there are some exceptions to that, but that's the standard rule. All right. All right, let's see. Excuse me. All right. The Secretary of Health and Human Services administers the Medicare and Medicaid programs, which provide health insurance for millions of elderly, disabled, and low-income Americans. In November of 2021, the Secretary announced that in order to receive Medicare and Medicaid funding, participating facilities must ensure their staff, unless exempt for medical or religious reasons, are vaccinated against COVID-19. 2 district courts enjoined enforcement of the rule, and the government now assists... Apologize. Excuse me. 2 district courts enjoined enforcement of the rule, and the government now asks us to stay those injunctions. Agreeing that's entitled to such relief, we grant the application. The Medicare program provides health insurance to individuals 65 and older, as well as those with specific disabilities. The Medicare program does the same for those with low income. Both Medicare and Medicaid are administered by the Secretary of Health and Human Services, who has general statutory authority to promulgate regulations as may be necessary to the efficient administration of the functions for which he's charged. One such function, perhaps the most basic, given the department's core mission, is to ensure the healthcare providers who care for Medicare and Medicaid patients protect their patients' health and safety. Such providers include hospitals, nursing homes, ambulatory surgical centers, hospices, rehabilitation facilities, and more. To that end, Congress authorized the Secretary to promulgate, as a condition of facilities' participation in the programs, that would be Medicare and Medicaid, such requirements as he finds necessary in the interest of health and safety of individuals who are furnished services in the institution. Thank you, Anonymous, for your $20 donation to help bring awareness and provide support to bone marrow transplants. It is extremely appreciated. Thank you. Okay. Relying on these authorities, the Secretary has established a long list of detailed conditions with which facilities must comply to be eligible to receive Medicare and Medicaid funds. Such conditions have long included a requirement that certain providers maintain and enforce an infection prevention and control program designed to help prevent the development and transmission of communicable diseases and infections. On November the 5th of 2021, the Secretary issued an interim final rule amending the existing conditions of participation in Medicare and Medicaid to add a new requirement, that facilities ensure that their covered staff are vaccinated against COVID-19. The rule requires providers to offer medical and religious exemptions and does not cover staffs who telework full-time. A facility's failure to comply may lead to monetary penalties, denial of payment for new administration, and ultimately termination of participation in Medicare and Medicaid. All right, so we have the thing set up, right? This is part of the government funding provision, right? The government using the power of the purse. The government has Medicare and Medicaid. Hospitals are allowed to take this or not. They don't have to. It is a program that's provided by the government. If you do take the money comes with strings. This is one of the ways the government gets to do stuff, is through the money power. Because states and hospitals like to go, yay, money. And so they take the money, and the money comes with things because the government says, if you want our money, if you want this big pile of money, you have to do things. And they're subject to our regulations. And one of the regulations might be, for example, whether or not you have to take this vaccine. So the question is, what is the authority for the Secretary of Health and Human Services to require this as part of the condition of accepting the money? If you don't want the money, you don't have to accept the condition. But do you have to accept the condition? Because the Secretary of Health and Human Services can't do everything. So, let's see whether or not they can require this. 20 U.S. News says it's a lot of money. It is a lot of money. It's a lot of money. It is a very big stick, yes. Or very big carrot, I guess. The Secretary issued the rule after finding vaccination of healthcare workers against COVID-19 was necessary for the health and safety of individuals who care for for the services that are furnished. In many facilities, 35% or more of staff remain unvaccinated. This was apparently true at the time the case was being decided, obviously. May be less true now. And of those staff, the Secretary explained, they pose a serious threat to health and safety of patients. That determination was based on data showing the COVID-19 virus can spread rapidly among healthcare workers and from them to patients, and such spread is more likely when they are unvaccinated. Again, this may or may not continue to be true, but these were the findings at the time. And the question might be whether or not the agency had a basis to believe them at the time, regardless of what might be true now, because we can only determine things based on the time that they're adopted. So, pressing on whether or not these are true in some absolute sense, we will just say that they were true for the purposes of the exercise because they were true, or at least true enough at the time the regulation was adopted. Let's press on. He also explained that because Medicare or Medicaid patients are often elderly, disabled, or otherwise in poor health, transmission of COVID-19 to such patients is particularly dangerous. In addition to the threat posed by inter-facility of transmission itself, the Secretary also found that fear of exposure to the virus from acts of unvaccinated health care can lead patients to themselves foregoing to seek medically necessary care, creating further risk to patient health and safety. Further noting that staffing shortages caused by COVID-19 relating exposure or illness has disrupted patient care. Again, these are findings that are being made at the time the regulation is going into effect. So, again, whatever is true now is a little neither here nor there because we're going to whether or not the agency could form the regulations based on what they knew, or at least said they knew at the time. The Secretary issued the rule as an interim final rule rather than through typical notice and comment. After finding good cause, it should be made effective immediately. The good cause was, in short, the Secretary's belief that any further delay would endanger patient safety given the spread of the Delta variant and upcoming winter season. We're going back in time, obviously. Shortly after the interim rules announcement, two groups of states, one led by Louisiana and another by Mississippi, filed separate actions challenging the rule. The United States District Court for the Western District of Louisiana and the Eastern District of Missouri each found the rule to be defective and entered a preliminary injunction against enforcement. In each case, the government moved for a stay of the injunction from the relevant Court of Appeals. In Louisiana, the Fifth Circuit denied the motion. In the Eighth Circuit, they did so as well. The government filed an application asking us to stay the injunction, and we heard expedited argument on request. So, the district courts and courts of appeal have said no, this was an improper regulation, and also we're not going to issue an injunction. The U.S. Supreme Court, acting expeditiously, says, okay, fine, we're going to consider both of these, and we're going to decide it on the merits as well. All right, so let's do that. First, we agree with the government that the Secretary's rule falls within the authority that Congress has conferred. Congress has authorized the Secretary to impose conditions on the recipient of these federal funds that the Secretary finds necessary to be in the interest of health. COVID-19 is highly contagious, dangerous, and especially for the patients at issue, a deadly disease, because they do tend to be elderly, which I think is definitely a risk factor. The Secretary for Health and Human Services to determine the vaccine mandate will substantially reduce the likelihood that healthcare workers will contract the virus and transmit it. Again, the degree to which this is true under the current factual posture is not necessarily the question, because we're trying to determine whether or not the regulation was proper, which goes into what the Secretary did or did not know at the time the regulation was promulgated. The Secretary of Health and Human Services determined that COVID-19 mandate will reduce the virus. He accordingly concluded the vaccine mandate is necessary to promote and protect the patient health. The rule thus fits neatly within the language of the statute. So this is just going to be statutory through and through, right? The Congress says, would you like some money? Everyone goes, yay, money. The money comes with conditions. Everyone goes, yay, money. Here's some of the conditions. It's just spending power. So it makes logical sense. After all, ensuring that providers take steps to avoid transmitting the virus to their patients is consistent with the fundamental principle of medical profession. First, do no harm. It would be the very opposite of efficient administration for the facility that's supposed to make people well to make them sick. The states and Justice Thomas offer a narrower view of The various authorities at issue contending that they seemingly broad language cited the above authority to impose no more than a list of bureaucratic rules regarding the technical administration of Medicare and Medicaid. But the long-standing practice of Health and Human Services in implementing the relevant statutory authorities tells a different story. As noted above, healthcare facilities that wish to participate in Medicare and Medicaid, again, you don't have to, you just give up a huge pile of money, have always been obligated to satisfy a host of conditions that address safe and efficient provision of healthcare, not simply accounting. Such requirements govern, for detail, for example, the amount of time after administration or surgery which a hospital patient must be examined and by whom. The procurement, transportation, transplantation of human kidneys, livers, lungs, and pancreas, the task that may be delegated by a physician to a physician assistant or nurse, and most pertinent here, the programs that hospitals must be implemented to govern the surveillance, prevention, and control of infectious disease. Moreover, the Secretary routinely imposes conditions of participation that relate to qualifications and duties of healthcare workers themselves. And the Secretary is also The Secretary has always justified these sorts of requirements by citing authority to protect patient health and safety. As these examples illustrate, the Secretary role in administering Medicare and Medicaid goes far beyond that of a mere bookkeeper. Indeed, respondents do not contest the validity of this long-standing litany of healthcare regulations. When asked in oral argument whether the Secretary could, using the very same authority, requiring hospital employees to wear gloves, sterilize instruments, wash their hands in certain ways and at certain intervals, Missouri answered yes. The Secretary certainly has authority to implement all kinds of infection control measures at the facilities. It's one of the conditions by taking the money. Of course, the vaccine mandate goes further than what the Secretary has done in the past to implement infection control. But he's never had to address an infection problem of the scale and scope before. I mean, since the office has existed, this is true enough, I suppose. In any event, there can be no doubt that addressing the infection in Medicare and Medicaid facilities is what he does. I mean, that is definitely one of his roles in life, yes. And his response is not surprising. Vaccination requirements are a common feature of a provision of healthcare in America. Healthcare workers around the country are ordinarily required to be vaccinated for diseases such as hepatitis B, influenza, and measles, mumps, and rubella. As the Secretary has explained, these pre-existing state requirements are a major reason the agency has not previously adopted vaccine requirements as a condition. So why have we not previously adopted vaccine requirements? Well, because under relevant state law, they are typically required to be vaccinated anyway, so there was really no reason for us to do this. This is a new vaccine and is not being required by the states, at least up to this point. So now there's a reason. These are Medicare and Medicaid facilities. The elderly are particularly vulnerable to COVID. This seems to be well true. If you look at the numbers of COVID, it does seem very much the case that the elderly are significantly impacted. Is vaccinating the healthcare workers a way to prevent transmission or to ensure their health? Well, the question is, of course, what did we know at the time of the regulation? Is the question of, will this help? And even if it's not perfect, it doesn't have to be perfect, because a lot of measures aren't necessarily perfect. So the question is it helpful? Does it help? Which is a different question, incidentally, to is it perfect? So even under current numbers, it might be very helpful to reducing the infection. So is this a kind of thing that he can do? Well, the Secretary of Health and Human Services has wide-reaching authority because Congress says he does. He has wide-reaching authority under a statute. Congress has the authority because it's part of the spending power. Congress's authority comes from the would you like some money provision of the Constitution. And everyone goes, yay, money. So this is one of the things that comes with the money. So it makes perfect logical sense from basic statutory principles. Whether or not you think it's an effective thing to do or whether or not you think it's a good thing to do, it's something that makes total sense from the principles of the statutes we're trying to interpret. Sig Sauer, I have contacted Legal Mindset on DM. And that's all I'm going to say. This is not a drama channel. So I will just say that I've contacted him privately, where I think these things are best resolved. But states give the Fed power? Sure. And one of the powers they gave the federal government was the ability to spend money. So, yeah. All this perhaps is why healthcare workers and let's try that again. All this is perhaps why healthcare workers and public health organizations overwhelmingly support the Secretary's rule. Indeed, their support suggests that vaccination requirements under these circumstances is a straightforward and predictable example of health and safety regulations that Congress has authorized the Secretary to impose. We accordingly conclude the Secretary did not exceed the statutory authority in requiring that, in order to remain eligible for the dollars, the facilities required by the interim rule must ensure their employees are vaccinated against COVID-19. I don't know that I need to really read any more of this. No, I think that's enough. Thus, that brings us to the end of this case of Biden versus... What's the formal name of this case? Biden versus Missouri. Okay. Thus, that brings us to the end of this case of Biden versus Missouri, a case dealing with COVID-19 mandates. In this particular case, however, the mandates are coming as a provision of the federal government's funding power, their spending power. They would like to have Medicare and Medicaid. One of the ways they do that is by giving money. And they say, hey, facilities, would you like some money? And they say, yes, we would very much. Now, the relevant statutes that Congress passed says that Health and Human Services can, make sure the facilities are up to snuff, including through health measures. And the statutory language is broad enough to cover this, which it does seem to be. This seems to be within the province of the Health and Human Services. Excuse me. So it makes total logical sense, therefore, that this is part of the provisions that the health administration has put in place. So if you want the money, it comes with these conditions, and that brings us to the end of consideration of this case. For today's story, we talk about vaccine mandates and whether or not the federal government can require those mandates as part of a condition of accepting money from federal programs. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education, and today will be the day I earn that subscription. For today's case, we are talking about the COVID-19 mandates. Yes, these were very, very controversial, and the federal government tried it in several different forms, some of which were successful and some of which were not. Today, we're going to talk about one of the successful ones, in the case of Biden versus Missouri. In this case, the administration required facilities that were accepting Medicare and Medicaid to also require to vaccinate their employees. So this is part of the spending power of the United States. And the question is whether or not the relevant statute allows for this to be part of the conditions of accepting the money. Do you, by accepting the money, have to accept the conditions? Well, let's get started with this. That was very good. I'm having fun. All right, I need to take a brief break for a restroom and also to get some water because I have well run out. But never fret, my friends. We will be back in just a few short minutes with more streaming time. And let's see, we need a break and we need some music, I think. Yeah. So if I put on music, will it do what I want to do? Let's find out. Let's see. What do I have rights to? Oh, I have rights to chill hop music. Hold on. Let's do this because I have rights to this. There's a little background music while I'm waiting. Okay, do this, do this. Hello again, friends. We're back. Alright, so let's see, where were we? Alright, we did Bind versus NFIB versus OSHA. We covered that, didn't we? I know we covered NFIB. Alright, let's skip NFIB for now. Let's go to Hemphill versus New York. Okay, this will be interesting. / depressing. Alright. Let's put in a timestamp. 1:56. It'll be more like 1:57. And 05. And put this timestamp in it. Great. Ooh, it was revised, really. Ooh. Unless it's just a minor typo. I'm not even sure what the typo was, but they issued a correction. All right. Okay. All right. Thank you for anonymous $20 for super chats. Thank you very, very much. Old wives' tale: if you wear a hat indoors, your hair will fall out. It's part of my brand, though, and I like the hat. And yeah, so you know, we'll make do. In April of 2006, a stray 9mm bullet killed a 2-year-old child after a street fight in the Bronx. Eyewitnesses described the shooter as wearing a blue shirt or sweater. Police officers determined that Ronell Gilliam was involved and that Nicholas Morris had been at the scene. A search of the apartment revealed a 9mm cartridge and 3 .357 caliber bullets. Gilliam initially identified Morris as the shooter, but he subsequently said that Daryl Hemphill, Gimmel's cousin, was the shooter. Not crediting Gilliam's recantation, the state charged Morris with the child's murder and possession of a 9mm handgun. In a subsequent plea deal, the state agreed to dismiss the murder charges against Morris if he pled guilty to a new charge of possessing a .357 revolver, a weapon that had not killed the victim. Years later, the state indicted Hemphill for the child's murder after learning that Hemphill's DNA matched a blue sweater found in Gilliam's apartment shortly after the murder. After the trial, Hemphill elicited undisputed testimony from a prosecution witness. The police had recovered a 9mm ammo from Morris's apartment, thus pointing to Morris as the culprit. Morris was not available to testify at the Hemphill trial because he was outside the United States. Relying on People v. Reed and over the objection of Hemphill, the trial court allowed the state to introduce parts of the transcripts of Morris's plea allocution to the .357 gun possession charge as evidence to rebut Hemphill's theory that Morris committed the murder. The court reasoned that although Morris's out-of-court statements had not been subject to cross-examination, Hemphill's arguments and evidence had opened the door, and admission of the statements was reasonably necessary to correct a misleading impression that Hemphill had created. The state, in its closing argument, cited Morris's plea allocution and emphasized that possession of a .357 revolver, not murder, was the crime Morris committed. The jury found Hemphill guilty, Both the New York Appellate Division and the Court of Appeals confirmed. Okay, so what we've got is two people involved in a potential murder relating to a child. One of them pleads guilty to simple possession of a .357 revolver. Initially charged with murder, but he makes a plea deal. And he pleads to .357, which isn't the bullet that killed the child, but that's what we got. Sometime later, the other person is now the suspect. We found DNA on the sweater, a sweater that looks like the sweater of the day. And we found 9mm ammo and so forth. So we have some evidence that suggests that he's involved. Now, what we want to do is we want to offer the statement of the other guy who had previously confessed to possession of the .357 revolver to dispel some of the claims that are being made by this defendant. So that we want to say, oh, wait, no, that he's saying some things, but here's an allocution we want to argue against that pushes against it. Now, we can't get to the guy. He's not available, but we're going to try to issue his allocution. The problem, of course, being that he's not available for cross-examination. So it's an out-of-court statement made by someone else and not him, but it's being used against him and without the ability to confront your witnesses. This seems pretty suspect. All right, so let's give this a shot, see what happened. The trial court's admission of the transcript of the plea allocution over Hemphill's objection violated his Sixth Amendment right to confront witnesses. This is totally correct, right? Mauritz pled guilty to possession of a .357 revolver. His plea is admissible against him, but there's no connection. They're not co-conspirators. So you can use the confession of one against the other. They're not that. So just using it doesn't make any sense. The state's threshold argument that Hemphill's failure to present his claim adequately to the state court should prevent the court from deciding his federal law challenge to a state court decision is rejected. Hemphill satisfied the presentation requirement in state court. At every level of his proceeding in state court, Hemphill argued the admission of the plea allocution violated his Sixth Amendment right to confrontation, as interpreted by this court. And once a federal claim is properly presented, a party can make any argument in support of the claim. So he did properly preserve his claim, so he didn't lose it, so he can use it. The Confrontation Clause of the Sixth Amendment provides a criminal defendant the bedrock right to be confronted with witnesses against him. In Crawford v. Washington, OG original hardcore case, Holla, the court examined the history of the confrontation right in common law and concluded that the principal evil at which the Confrontation Clause was directed was the civil law mode of criminal procedure, which allowed the use of ex parte examination as evidence against the accused. The civil law system has different evidentiary standards, including the admission of ex parte evidence, so not so much with that. The Crawford court reasoned that because the Sixth Amendment does not suggest that any open-ended exceptions from the confrontation requirement to be developed by the courts, the confrontation guarantee was most naturally read to admit only those exceptions that existed at the time of the founding. This is how we typically interpret constitutional rights. We typically interpret them as they existed at the time of the founding. So what is the confrontation right? What is the right to confront one's witnesses? Well, it is the right to confront one's witnesses. So as always, what do we have to do? We have to do a historical analysis. As the Supreme Court recently reminded us in Second Amendment land, it's no different in Sixth Amendment land either. We have to do a historical analysis. We have to find out, what did the right include? What doesn't it include? What exceptions, such that they are applied? Because if they weren't recognized as part of the right, then they're not within the confines of the right. So yeah, we have to go do a historical analysis to see what was allowed for or not at the time. Okay. Because the framers would not have allowed admission of testimonial statements of a witness who did not appear at trial unless he was unavailable to testify, and the defendant had a prior opportunity for cross-examination, the court rejected the previous reliability approach to the Sixth Amendment described in Ohio v. Roberts, which had permitted these admissions and statements of unavailable witness so long as the statements had adequate indicia of reliability. So yeah, before Crawford, which was relatively recent, it's like 20 years old or something like that, if that, the Supreme Court used to allow a lot more statements against you, and then they decided that was kind of dumb because of the Sixth Amendment. The court rejects the state's contention that opening the door rule incorporated in People v. Reed and applied here is not a confrontation clause exception at all, but merely a procedural rule that limits not only the manner of asserting the right, not its substantive scope. While the court's precedents do recognize the Sixth Amendment leads states with flexibility to adopt reasonable procedural rules that bear on the exercise of the defendant's confrontation rights, the door-opening principle discussed in Reed is not the same class of procedural rules. The door-opening principle is a substantive principle rule that dictates what material is relevant and admissible. The state would have trial judges weigh the reliability or credibility of testimonial hearsay evidence, but that approach would negate Crawford's emphatic rejection of reliability-based approach to the Confrontation Clause guarantee. Here, it was not for the trial judge to determine whether Hemphill's theory that Morris was the shooter was unreliable, incredible, or otherwise misleading in light of the state's proffered, unconfronted plea evidence, nor was the evidence reasonably necessary to correct the misleading interpretation. So, yeah, basically this is just an extension of Crawford. Crawford basically gave you an enhanced right to confront your accusers, and it's relatively recent in Supreme Court history. Before that, the leading case on point, Ohio versus Reinhart, said, yeah, basically it's just whether or not sufficiently reliable. So this was basically where hearsay exceptions came into play. And the Supreme Court said, no, you actually have a right to confront your witnesses because that's what the Constitution says. So, unsurprising. So, therefore, it is not, left to the trial judge to determine whether or not, it's good or not. These decisions have been made. And so, since he's unavailable to testify and be cross-examination and has never been cross-examined, his confession can't come in, is an unconfronted statement in the context of this trial. To the 209 of you who are currently watching, it's appreciated. I hope you're enjoying this stream for as long as it lasts. And we're getting some good legal education in. Learning about what the Supreme Court did this past term. It's good stuff. The court also rejects the state's insistence that the Reed rule is necessary to safeguard the truth-finding function of courts because it prevents selective and misleading introduction of evidence. The court has not allowed such considerations to overrule the rights of the Constitution that it confers to criminal defendants, and none of the cases the state relies on for support involve exceptions to a constitutional requirement. The state's concern that The state's concern that reversal will leave prosecutors without recourse to protect against abuses of confrontation right is overstated. I'm not sure how you can necessarily abuse something that's technically a right, but okay. Well-established rules of evidence permit trial judges to exclude evidence if its probative value is outweighed by certain other factors, such as unfair prejudice, confusion of the issues, or potential to mislead the jury. Finally, the rule of completeness does not apply here, as Morris's plea allocution was not part of any statement that Hemphill introduced. The court does not address whether and under what circumstances that rule might allow the omission of testimonial hearsay against a criminal defendant. Because, yeah, it was not something that he introduced. So if Hemphill had introduced part of the statement, then maybe, but he didn't, so no. Thus, that brings us to the end of the case of Hemphill versus New York, a case that is describing further the right of confrontation. You have a right to confront the witnesses against you. The Constitution says so. Somewhat unfortunately, until relatively recently, the decision in Crawford, this right was not as broad as it should be. But now the right is much broader, as it should be. And so now this is just further extending out that logic. This guy has some testimony that might be relevant to the prosecution. It might be very relevant to the prosecution, but he's not available for testimony because he's not inside the country anymore. So they can't just merely offer his own confession against him. If Hemphill, the guy being charged, had offered parts of his statement, then maybe, from rules of completeness, sure, but he didn't. He's objecting to it every step of the way. And so no, you can't actually offer that statement against him. So that makes total logical sense, is in accordance with the Sixth Amendment's clear text, and at least for the moment, brings us to the end of discussion of this case. What are you talking about? You don't know how you can abuse something that's a right? Because it's your right. I mean, if you have a right, I'm not quite sure, that you can abuse it if it's your right. Because it's a right. Abusing, I'm not quite sure that makes sense, but okay. I'm not quite sure how that makes sense. Once you decide it is a right, you can have a discussion about whether or not something is a right in the first place. But once you decide it's a right, I'm not sure then how you can then turn around and say, but it's abusive to use it. Strange. It's a strange proposition. Maybe we just have a different understanding of the word abuse. I don't know. For today's story, we talk about the confrontation clause and your ability to confront the witnesses against you in a court of law. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with a case that deals with the right of confrontation of the witnesses against you at trial. This is the case of Hemphill versus New York. In this case, a guy was on trial for murder, and there was a statement from a different guy who had confessed to possession of a firearm. Now, this in some sense was going to help the state, or at least the state thought it would help, in their case against this guy. So they wanted to offer the confession of the other guy against him. But the other guy wasn't available for trial. He wasn't available for cross-examination. He was out of the country. And so they wanted to use his plea deal confession against him. Not against the guy who confessed, against the other guy. And the other guy says, wait a second, that's a violation of my right to confront. I have a right to confront the witnesses against me. This guy has some sort of evidence that might be used against me. I have a right to confront that in cross-examination. The trial court said no. But today, the U.S. Supreme Court has to examine how far the right to confront goes. Let's get started with this. Excellent. Fine. Good times. What is next? Let's see. So many cases for me. So many cases for free. Look out. All right, what is this? Hughes versus Northwestern. Okay. Let me add the stream tag to the stream. This is becoming an interesting stream for sure. Nothing is free in life. Okay. She business, is that her real name? Well, it's her name now, apparently. Wasn't her name at birth, but yeah. All right, color correction card time. Try to do this every once in a while to make sure that I can do it if I want to. Correct color. This is going to be an interesting one to edit for sure. This is going to take a couple days to edit. That's okay. Good content. Where am I? Okay. Respondents administer retirement plans on behalf of current and former Northwestern University employees, including petitioners here. The plans are defined contribution plans governed by the Employee Retirement Income Security Act of 1974, under which each participant chooses an individual investment mix from a menu of options selected by the plan administrators. Petitioners sued respondents, claiming that the respondents violated the duty of prudence required by all plan fiduciaries by failing to monitor and control record-keeping fees, resulting in unreasonably high costs to plan participants, offering mutual funds and annuities in the form of retail share classes that carried higher fees than those charged by otherwise identical share classes of the same investments, and offering opportunities that were likely to confuse investors. The district court granted respondents' motion to dismiss, and the Seventh Circuit affirmed, concluding that they failed as a matter of law. Okay, so we've got some plans admitted for retirement. You get to choose your plans, which plan retirement you would like, and we're suing, saying that the plan administrators are doing a bad job. They're offering the wrong plans. The plans are confusing. We don't understand the plans. People don't understand the plans. It's confusing, and so forth and so on. So all that stuff. So yeah, we're going to try to sue them. This doesn't sound like that's going to work because, you know, which plans to select and how so forth and so on. Unless it's just blatantly horrible, it's probably going to be fine. All right, so let's go ahead and see how this is reasoned. The Seventh Circuit erred in relying on participants' ultimate choice over their investments to excuse allegedly imprudent decisions by respondents. Determining whether petitioners state plausible claims against plan fiduciaries for violation of their duty of prudence requires a context-specific inquiry of fiduciaries' continuing duty to monitor investments and remove imprudent ones as articulated by the law. The law concerns allegations that plan fiduciaries have offered high-priced retail class municipal funds as plan investments when materially identical lower-priced institutional class mutual funds were available. The court has concluded that plans have identified a potential violation with respect to certain funds because a fiduciary is required to conduct a regular review of the investment. The discussion of continuing duty to monitor plan investments applies here. Petitioners allege that respondents' failure to monitor investments prudently by retaining record keepers that charge excessive fees, offering options likely confuse investors, and neglecting to provide cheaper and otherwise identical alternative investments resulted in respondents' failure to remove imprudent investments from the menu of offerings. In rejecting the allegations, the Seventh Circuit did not apply the court's guidance, but instead erroneously focused on another component of a duty of prudence, a fiduciary's obligation to assemble a diverse menu of options. But respondents' provision of an adequate array of investment choices, including lower-cost investments plans wanted, did not excuse the allegedly imprudent decisions. All right. So what the Supreme Court is saying here is that the fiduciary here, the fund managers, are required by the relevant law to produce funds that are suitable. The way that the funds are suitable is by looking at a combination of things, as you would expect. Like, what are the costs of the funds? What is the returns of the funds? What is the ability of the funds to be good funds? And the people complaining have said, look, some of these funds are just bad because there are lower funds available that do exactly the same thing. So you're just offering bad plans, or they are no longer good returns on investment, and you're not trimming the plans out. The response was, well, yes, but we've offered the plans that you wanted. The Supreme Court says that's not enough, because it's not enough to merely offer the good plans. You must also trim out the bad plans. That's part of your fiduciary obligation. As a fiduciary, you have an obligation to your client to offer them good options. You can't excuse it by saying, oh, I'm offering you good options in addition to bad options, and it's your choice. One of your roles as fiduciary is to eliminate the bad choices. And here they're clearly bad, or at least arguably clearly bad. So therefore, there is an obligation to reduce them, and you didn't. So that's what's going on. The plan administrators, although they may have added plans that are good, they didn't do enough to reduce the plans that are bad, or at least that's the argument. Oh yeah, no, this isn't for me personally. I don't need bone marrow. This isn't for me personally. It is for Stephanie, though. Because, you know, we've talked about her diseases, and I want to bring attention to something that would, you know, be helpful. I don't need bone marrow yet. Maybe someday. Okay. Even in a defined contribution plan where participants choose their investment, the law instructs that plan fiduciaries must conduct their own independent evaluation to determine what investments may be prudently included in a plan's menu of options. If the fiduciaries fail to remove an imprudent investment from the plan within a reasonable time, they breach their duty. The Seventh Circuit's exclusive focus on investor choice elided this aspect of the duty of prudence. The court maintained the same mistake focus in rejecting petitioner's claim with respect to record-keeping fees on the ground that plan participants could have chosen investment options with lower expenses. The court vacates the judgment below so the Seventh Circuit may reevaluate the allegations as a whole, considering whether petitioners have plausibly alleged a violation of the duty of prudence. The content of the duty of prudence turns on circumstances prevailing, so the appropriate inquiry will be context-specific. So, and this is a unanimous decision. And we don't know, of course, whether or not they have been imprudent, because the Seventh Circuit said merely it was sufficient that they offered the plans that they wanted, good plans. It was merely sufficient they offered good plans. The Supreme Court says, well, that's not merely sufficient, so go back for further finding. So we don't know whether or not they did enough to trim out bad plans or not, but at least it's a question that the court below has to consider in the first instance. Let's wrap this up. And I might have to break for lunch. I mean, we have done, let's see, this will be 1, 2, 3, 4, 5, 6 cases. It's a lot of cases. Thus, that brings us to the end of the Supreme Court case of Hughes versus Northwestern. In this case, the plan administrators for retirement plans offered some plans that were good, but they might have offered some plans that were bad. The people in the plan say, hey, you're offering plans that are bad and you're confusing people. And they said, well, it's merely enough that we offered good plans. The Supreme Court says, no, under the relevant law, it is not enough. You merely offer good plans. You also have to trim out plans that are bad. Now, whether or not they did that or not, or whether or not the plans are bad enough or whatever to be a breach is a whole nother set of problems. But it's not merely enough that they offered good plans. So the United States Supreme Court returns this case back for further analysis, and that for the moment brings us to the end of consideration of this case. For today's case, we talk about fiduciary duty of people offering retirement plans and what obligations they have to make sure that the plans that they are offering meet minimum standards. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's coverage, we're discussing Hughes versus Northwestern. Northwestern offers retirement plans, and they offer many different retirement plans. The people in the plans say that some of these plans are bad, however. They are not good plans. They are not sufficiently good in terms of their costs or what they're getting in return. They have problems. Northwestern says it's enough that they offer good plans, and it's up to the person to choose for themselves what's good and bad, so it's not really their fault if they have any bad plans. Because as long as they have good plans, it's up to you to make the decision for themselves. Well, is that enough? Is it enough as a fiduciary that you offer good options, or do you also have some duty to exclude the bad? Let's get started with this. Woo. Yeah, I need at least a mental break for a second. At least a mental break. All right. I'm thinking about making some eggs. Eggs would be tasty and they wouldn't take very long. And I could just take a break and I wouldn't necessarily have to kill the stream. I could just take a 15-minute break while I make and eat the eggs, which is tempting. Or I could order food, which I don't know that I want to do today. Let's see what's next as I contemplate my food-related options. January. All right, that was the end of January. Let's go to February. All right. Copyright case. Fun. Just give me a second. How's everyone doing in chat today? Splendo? That's good. You're sick? That's bad. Oh, by the way, thank you, Q Squared. I'm not sure if I acknowledged your $20 super chat or not. I said super chat. Same. I'm not sure if I acknowledged your donation. Thank you, Q Squared, for the $20 for helping to support. That was a joke. Helping to support donations for bone marrow transplants. Don't forget that you can sign up to be a bone marrow donator as well. Help save a life today. I think I'm thinking about taking a break for lunch. I'm thinking about maybe taking a nap. Naps are badass. Let me read this case and we'll go from there. Okay. All right, so this is going to be the case of Unicolor versus H&M. Yeah. All right. Hat goes back on. All right. A valid... let me put the case name on screen. That's what I usually do when I'm reading it from the start, so that way people can follow along. Okay. A valid copyright registration provides a copyright holder with important legal advantages, including the right to bring a civil action for infringement of a copyrighted work. Petitioner Unicolor, the owner of copyrights in various fabric design, filed a copyright infringement action against H&M. A jury found in favor of Unicolor. H&M sought judgment as a matter of law, arguing that Unicolor could not maintain an infringement suit because Unicolor knowingly included inaccurate information on its registration application, rendering its copyright registration invalid. The alleged inaccuracy stemmed from Unicolor having filed a single application seeking registration for 31 separate works despite a Copyright Office regulation that provides a single application may cover multiple works, only if they're included in the same work of publication. All right, so this is dealing with how to register a copyright and how not. All right, so according to the Copyright Office, in order to register a work, you have to file a separate registration for each work. But what if the work contains subworks? So in that situation, you can file a copyright for all the combined works separately. So this would be like a compilation of different works. If you have a compilation of different works, you can file one for the compilation as a whole, and also each individual part of the compilation. So each individual component of the compilation becomes its own separate copyright, because it doesn't matter, like if it's contained in a longer work. Each of the separate works are separate works. So you can now in defining what the nature of the work is, in defining the nature of the work, you not only have to consider the total work, the total length of all the work, you also have to consider each component of the work, because each component of the work may be separately registratable. So when you're doing this, the question is, are you doing it properly? So if you have multiple independent works, they have to be filed separately. But if they're part of a compilation works, you can file them together. So the question is, did they script the registration? And if so, does it matter? All right. All right. All right. H&M argues that Unicolor did not meet this requirement because Unicolor had initially made some of the 31 designs available for sale exclusively to certain customers, while offering the rest to the general public. So they weren't part of the same work, is the argument. The district court determined that because Unicolor did not know when it filed the application and it failed to satisfy the single unit of publication requirement, Unicolor's copyright registration remained valid by operation of the safe harbor provision of law. On appeal, the Ninth Circuit determined that it did not matter whether it was aware that it failed to satisfy the requirement because the safe harbor excuses only good faith mistakes of fact, not of law. Unicolor had known the relevant facts, so its knowledge of the law or therefore was irrelevant. Okay, so the relevant copyright law provides a safe harbor provision. It's like if you make a good faith mistake, it doesn't matter, right? So if you make a good faith mistake, you're still okay. It only matters if you know that you're doing it wrong. If you know you're doing it wrong, then fine. That's one thing. But if you're making a good faith mistake, that's another thing. But the question is, what is the nature of the good faith mistake? Does it matter about the facts or the law, right? Because there is an idea, of course, that mistakes of law don't matter, right? Like, it doesn't matter how wrong about the law you are. Mistake of fact is one thing. Mistake of law, generally not a thing. But, of course, even in mistake of law, if the law allows for mistake of law, which it sometimes does, then mistake of law can be an excuse. So ignorance of the law can be an excuse if the law allows for it. And to find it, you have to look for it in statute. So the question is, when Congress said good faith mistakes, was this a situation where, hey, ignorance of the law is an excuse after all? All right, let's find out. Hell, the relevant law does not distinguish between mistake of law and mistake of fact. Lack of either factual knowledge or legal knowledge can excuse an inaccuracy in copyright registration. So yes, ignorance of the law is in fact an excuse in this particular context because the law specifically says so. The Copyright Act provides that a certification of registration is valid even though it contains inaccurate information, as long as the copyright holder lacked knowledge that it was inaccurate. Case law and the dictionary instructs that knowledge has historically meant and still means fact or condition of being aware of something. Nothing in the law suggests the safe harbor applies differently, simply because they made a mistake of law as opposed to one of fact. If Unicolor was not aware of the legal requirement that rendered information on its application inaccurate, it could not have included the inaccurate information with knowledge of the inaccuracy. So you have to have knowledge, and if you didn't have knowledge of the law, then you didn't have knowledge of the law. So at least the way this is written, again, as to this specific situation, ignorance of the law is an excuse. Only as to this situation, please don't try to overread this. If you do, you'll have a bad time. Nearby statutory provisions help confirm that knowledge refers to knowledge of the law as well as facts. Registration applications call for information that requires both legal and factual knowledge. Inaccurate information in registration may arise from mistake of law or mistake of fact. Nothing in the statutory language suggests that Congress wanted to forgive applicants, many of whom lack legal training, for factual, but not often esoteric, legal mistakes. It can be a little esoteric. Copyright law can be a little esoteric and a little bit difficult and a little bit treacherous. It is a complicated, or at least can be a complicated mess, which I suppose is true for most fields of law once you get into it. Moreover, had Congress intended the scienter, that's the knowledge requirement, to be anything other than actual knowledge, it would have said so explicitly, as it did in other parts of the Copyright Act. Indeed, cases decided before Congress enacted the law overwhelmingly concluded inadvertent mistakes on registration certificates, many of which involved mistakes of law, neither invalidated copyright restrictions nor disallowed infringement. The court finds no indication that Congress intended to alter this well-established rule when it enacted the relevant law. This is not fair use copyright. This is registration copyright. This is dealing with alleged problems in the registration of the copyright, and whether or not the registration was deficient, and whether or not, if deficient, it means the copyright registration is invalid. So this isn't dealing with fair use. This is dealing with whether or not the copyright was properly registered. So, yeah, fun times. Those who consider legislative history will find indications that Congress intended the law to make it easier, not more difficult, for non-lawyers to obtain valid registration. It did so in part by eliminating loopholes that allowed infringers to exploit mistakes in the application process to prevent enforcement of otherwise validly registered copyright. Given the history, it would make no sense if the relevant law left copyright registrations exposed to invalidity because of applicants' good faith misunderstanding of the details of copyright law. H&M's remaining arguments are unavailing. First, the court's interpretation of the statute would not allow copyright holders to avoid the consequences of an inaccurate application by claiming lack of knowledge. As in other legal contexts, courts need not automatically accept a copyright holder's claim they are unaware of relevant legal requirements. Willful blindness may support a finding of actual knowledge. So if you are deliberately obtuse and deliberately trying to avoid gaining knowledge, then that counts. You showed a willfulness to ignore, willfulness to be ignorant. That's different than just being ignorant. Okay. Additionally, circumstantial evidence may demonstrate that an applicant was actually aware of or willfully blind to legally inaccurate information. So there might be evidence that suggests that you didn't know. Second, the legal maxim that ignorance of the law is no excuse does not apply in this civil case concerning the scope of the statutory safe harbor that arises from ignorance of collateral legal requirements. Finally, knowledge question the parties have argued, and which this court decides, was a subsidiary question fairly included in the question presented. And Ninth Circuit explicitly addressed the knowledge issue that held when Unicolors' knowledge of the facts underlying accuracy on its own implication was sufficient to demonstrate knowledge without regard to knowledge of the law. Thus, that brings us to the end of the case of Unicolor versus H&M. In this case, we dealt with how does copyright become copyright registration. Copyright, as you may know, exists from the moment it is put onto a fixed medium. The very moment it becomes recorded in any sort of tangible medium whatsoever. That could be memory of a computer, it could be on a hard drive, it could be anywhere. As long as it exists in any sort of tangible medium, and even if it doesn't necessarily permanently exist, copyright exists. Now, copyright registration is another step, of course, entirely, but the copyright exists from the moment go. The question here is whether or not you have the proper copyright registration. To engage in proper copyright registration, you have to fill out a form. The relevant law provides that if you don't fill it out perfectly, it's okay as long as you didn't know. And the question is ignorance of the law okay? In this situation, yes, it is, because the statute specifically seems to allow for it. And Congress was trying to make excuses, trying to give more excuses for invalid registration because they didn't want registration to become an impossible bar for someone to apply in good faith. So this makes total sense. It's in accordance with what Congress wanted. And because it's statutory, that makes it relatively easy. And that, for the moment, brings us end of discussion of this case. For today's case, we discuss copyright law and when ignorance of the law is a valid excuse. Hello, everyone, and welcome to Uncivil Law, where we learn from the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with Unicolor versus H&M, a case dealing with copyright registration. There is, of course, a process to get copyright registration. If you want copyright itself, copyright exists from the moment it's put on a fixed medium. So copyright exists instantly. In order to get registered, however, you have to fill out some paperwork. It's a little bit perfunctory, but, still. And then there's a question of what happens if you screw up the paperwork. Does it defeat the copyright itself, or at least the copyright registration itself? And that's the case today. In this case, Unicolor made a mistake in its copyright registration. Does that, in a sense, make the copyright registration invalid? Well, that's the question the Supreme Court has to decide. Let's get started with this. And that, my friends, I believe will end our stream for now. This has been a good stream. We did, 7 cases? That is a lot of good cases. That is a lot of good cases and a lot of very necessary editing for me. So that is fun. I am going to make some food, I think. I think I'm going to have some eggs. I think I'm going to scramble some eggs, and it's going to be fun. And I'm going to eat the eggs, and it's going to be fun. And so that will be good. So, yeah. Should I make the stream unlisted? I think I'll keep it listed for now. and it'll be good. And yeah, because there's some good stuff in here. And yeah, maybe I'll make it unlisted later or something, because it is technically a batch record. So we'll see about all that. But, that's another decision for another time. And just in case I forgot, I'll do the color correction card one more time. It never hurts to have more of it. Because as lighting conditions change, you want to have the availability to do that. So we'll go from there. So, yeah. All right. Don't forget to like, comment, subscribe, do all the YouTube-y things. I've been Uncivil Law. Till later, my friends, I hope all is well. Cheers, my friends, and goodbye.